Well, welcome everybody. I can't see you, but I can see that you logged in. So it's really great to have you along. And we're going to get kicked off this morning on our employment law update, which we've titled 2023, the year of the employee. And that will be the kind of recurring theme through the presentation. In terms of introductions, this is me. So I'm Nick Elliott, head of the dispute resolution and employment team at Actons. I know a number of you will know me and the team, some are new. So just a little introduction. We are based in Nottingham city centre, and we work with a number of household names, some of which are on the slide there, as well as a high proportion of sort of SME businesses across the East Midlands and beyond. And we provide a full range of employment law and HR services, as well as a number of other commercial and private client services across the firm, so corporate, property, that kind of thing. The wonderful team will be assisting with the presentation today, in fact, doing most of the presenting today. There they are, and in particular, really pleased to have Rakaya presenting today. So Rakaya is a trainee in our team, has been with us for 6 months, is in her final week, but her first 6 months with the firm, and before she heads off elsewhere, and it's great to have her presenting today too. I don't think there are any other sort of housekeeping points. If you hear a fire alarm, it's probably that your house or office is on fire or having a drill. So do please leave us. But yeah, other than that, there's not too much. We're going to take some questions at the end of the session. So there is a Q&A section there. However, feel free to use the chat function to fire questions into there as we go, and because there are a number of us presenting, hopefully we can pick those up as we go as well. Again, anybody who's been on one of our sessions previously will know that we try and make this quite an interactive session, so there's some polls for you to vote on various issues, and we're really happy to kind of engage in the chat as well as we go. We will be jumping around on various subjects, so it might feel a little bit bitty at times, but we're trying to cover lots of the stuff that's coming in 2023 and to give it quite a broad range in terms of the subject matter. So bear with us on that. One of the things that I like to do at the beginning of these sessions is sort of set the scene or set the context in which HR professionals or people who are managing employees are operating at the minute, and obviously post-COVID it's a very different world, and there are different challenges, and increasingly employees are looking for more flexibility. That might be hybrid working, or it might be other types of flexibility. Salaries have obviously gone through the roof, and employers, I think, are increasingly battling with how to manage those things well, but also keep productivity levels high. I think there were some stats out recently that London is lagging behind other cities across the world in terms of productivity. So that's clearly a challenge for employers. And I think, interestingly, there have been some moves by the government to extend employee rights, which isn't always the case for a Conservative government. Or, in fact, there are bills progressing through Parliament at the minute, some backed by the Labour Party or initiated by the Labour Party, where actually it's looking like employee rights might be extended beyond what they are at the minute. That said, there's also legislation in play, which we covered in a previous webinar, which would actually repeal large swathes of employment law altogether, unless the government puts some new legislation in to replace that. So it's quite an uncertain time when it comes to employment law in that regard. And I'm sure if you wanted a copy of the recording of that webinar, we'd be more than happy to let you have that. But there are other pressures on employers as well. So being an employer of choice in order to recruit people, which is proving difficult in a lot of sectors, if not all sectors. The economic uncertainty that we've had in recent times, certainly in my lifetime, I don't really remember, it being like that. It's been very uncertain, and clearly cost of living and inflation is a real challenge for us all. And employees will be pushing for improved salaries. We've got strikes just yesterday, the teachers and the like. So yeah, it's an interesting time to be managing people. So we want to keep you up to date and give you a flavour of what's coming in 2023. These are some of the topics that we're going to be looking at. So flexible working, menopause, some new family-friendly rights. We're going to get up to speed on holiday pay, which has been a long-running saga for many years in terms of how that works and how it's calculated. We're going to look at some new guidance around fire and rehire. So the P&O case brought that into the focus in the media in a pretty significant way. And if you can stick with us to the very end, we'll then be talking about toilets, romantic overtures, and vanishing dismissals. Now, if that was a pantomime, there might be an ooh or something along those lines. But yeah, that's the case review that we're going to look at towards the end. And yeah, that's got some interesting stuff in it too. So I think we're going to kick off with a poll on the subject of flexible working. So this is where you guys get to take part, and it'll be interesting to see what the results of this are. So I think Matt, who's making all this work in the background, will launch the first poll for us. So it's a fairly straightforward question to kick us off. Have you seen an increase in the number of employees asking for flexibility in the way they work since COVID? So feel free to vote away. And I think, unsurprisingly, there's a fairly high response rate for yes. I think we've pretty much got everybody voted on that one. I think maybe there's 3 or 4 people still to go, but yeah, an overwhelming kind of reinforcement of the fact that post-COVID, employees are looking for more flexibility in the way that they work. Specific to flexible working, which of course is a statutory process set out in the law that employees can use to request that flexibility in a more formal way. The second question in the poll sort of covers this, and I think this will be interesting. So in the last 12 months, for those requesting flexibility in the way they work, have you received an increased number of formal flexible working requests? So that's usually in writing, it triggers that statutory process. Or has it been more informal inquiries about, please can I work in a different way? So again, I think probably I would have guessed that it might be leaning towards that more kind of informal inquiries. I think, although we within our client base have seen, I think, an increased number in formal requests, it's certainly the case that the kind of hybrid working and post-COVID sort of working environment has led to employees just engaging with their employers more informally as to how they might work in the form or sort of more flexibly, but that tends to be in an informal way, I think, increasingly. And I think we have one final question on this. So as an employer, do you feel more pressure to accept flexible working requests since COVID? So that's the third question there. And again, fairly straightforward, yes or no. And we'll just let the responses come through. Yeah, that's great. Thanks, everyone. That's pretty much everybody. I think that, again, that's not necessarily unexpected. I think increasingly it's made it difficult for employers to reject flexible working requests. And the classic, of course, being, well, I worked at home during COVID, so why can't I work at home now? It worked perfectly well then. And I think that might well be the case for some people. Of course, a number of employers are battling with the fact that some employees didn't work that well and that productively while at home during COVID, and that's why they want them back in the office. But certainly increasingly we're seeing, that flexibility is pretty essential for the purposes of retaining and recruiting talent. So that's great. Thanks everybody for your responses on the poll. Just to kind of update you as to where this appears to be going in terms of the formal flexible working requests. This is the current sort of key elements of that area. Sorry, I've skipped ahead a bit quickly there. So an employee has to have 26 weeks continuous employment with the employer. So it's not at the minute a day one right that you walk in and you can request flexible working in that way, in using the formal scheme at least. An employee can only make one request in a 12-month period. The employer has to respond to that within 3 months. So the idea is it's done relatively promptly. And as part of their request, the employee should specify how the employer might deal with the impact of that request on the business and their colleagues. Then, when considering the request, the employer can refuse it on the basis of 8 statutory business grounds, which I won't bore you with, but they basically relate to the practical implications of allowing that person to work more flexibly or in the way that they're requesting, and the cost implications of that. So they are generally what employers will rely on. Well, they are what employers will rely on under this process, should they want to reject a flexible working request. But there is a bill progressing through Parliament which covers this issue and is likely to result in flexible working becoming what they're describing as a day one right. So effectively, from day one in your employment, you will be able to request flexible working using the statutory scheme process. Other likely changes are that the employer will have to more formally consult with the employee if they're considering rejecting that request. The employee, rather than having the ability to make one request in a 12-month period, will actually be able to make 2 requests in that 12-month period. The response time for the employer is also reducing from 3 to 2 months, and it will also likely remove the need for the employee to specify that impact that their request will have. So they won't have to worry about that. That will be for the employer to deal with and assess. What's not changing are the 8 statutory business grounds for refusing that request. So you'll see that this sort of the wind of change, or the direction of travel, I should say, is that it's becoming more favourable for the employee, but therefore more onerous for employers. And I think that the challenge also will be the fact that it could apply from day one, which James and I were talking about yesterday, could practically be quite tricky for employers who recruit somebody on the basis of a certain sorry, the chat's going wild with comments around the slide, so hopefully we can get that sorted if you can't see them. The practicality of that day one right, where you employ somebody on a certain basis, certain hours, certain place of work, that kind of thing, and then day 2 they file a flexible working request to change that. And I think employers may well have to deal with that kind of situation. I suspect it might be quite an easy and straightforward response, which is, no, you knew that you were coming to work on this basis. This isn't something we can accommodate, because we structured this role in a way based on these business reasons that we needed. So yeah, it will be interesting to see where that goes. As I say, at the minute, this is progressing through Parliament, and therefore it it is subject to change, but it's likely, I think, to go this direction on the basis that the government is committed to extending this right. So we have our next poll, and the question. So we're moving on to the topic of menopause, and this has been in the press, in the media, kind of in the HR press in particular, in a pretty big way recently. And the question is, do you think changes should be made to the law to provide greater protection for menopausal employees? And that's, again, a simple yes or no answer. So our poll is probably at the minute 2/3 or 3/4 in favour of yes, greater protection. And it's interesting. We've run a number of sort of roundtables with HR directors, and the feedback from that kind of cohort has been, actually, we don't think we need that additional protection, specifically because actually, employers and HR teams should be able to deal with whatever challenges employees are facing in a sort of compassionate and appropriate way. So it's interesting, this whole area. We're not going to go into it in major detail, but very recently there was a response to an independent report that was carried out, making various recommendations as to what the government might consider in this area. From an employment law perspective, one of the changes that was proposed was that menopause would become a protected characteristic within the Equality Act, alongside things like age, sex, race, and so on. But actually, in reality, the government has rejected nearly all of the recommendations of the report, including making menopause a protected characteristic, and instead has said that they'll introduce a menopause employment champion to report on progress in this area. So I suppose it's to update you on the fact that that was a potential that that people were asking for, that the government have rejected that idea, but I suspect that it won't be the end of the issue, and I think clearly it's an important one, and I think there'll be more here, but at the minute it's not likely to be set out as a protected characteristic separate to the others. Part of the government's reasoning, and I see this, I think, is that other protected characteristics such as sex and disability might well cover situations where menopause is impacting on somebody's ability to carry out day-to-day activities, which is the disability angle. Now, whether people like it being labelled that way or would prefer it separate, as was suggested, is a different thing, but I think there is some protection. In fact, there are some tribunal cases around that as well. So that's menopause, and I did say we would be jumping around a little, but when next onto third-party harassment, and I'm going to shut up and let Laura talk. But third-party harassment, essentially harassment by third parties of your employees, of your people. So it's an interesting area. Laura.
Cool, thank you. Good morning, everybody. So I'm going to start by taking you through the stuff on third-party harassment. Just to clarify, this is harassment by a third party in your workplace towards your employees. So not employee to employee, but someone coming in like a contractor or a supplier. For those of you that can see the slides, hopefully all of you now, you'll see that there was some third-party harassment provisions previously in the Equality Act. They went away in 2013. So as a bit of a recap, between 2010 and 2013, there were some specific rules on third-party harassment, which made employers liable for harassment where they failed to take such steps that would be reasonably practicable to prevent the harassment, and they knew that the employee had been harassed by a third party at work previously. There was then a case brought in 2018, which is the case on the slide, that went all the way up to the Court of Appeal, and the Court of Appeal basically said, okay, actually, no, there is no third-party harassment provisions left in the Equality Act. They have gone, and therefore there is no longer the employer's liability for failing to protect employees against third-party harassment. And they actually made recommendations at that point that the government looked into this. There's then been some new reviews that have come over the last few years between 2018 and now, where there's been further parties looking at whether they should bring back in rules surrounding third-party harassment, and they're finally getting around to looking at that. So if we go on to the next slide, you'll be able to see the proposed new harassment at work law. So as you can see, employer A is treated as harassing employee the employee in the course of employment, and if they failed to take all reasonable steps to prevent the third party from doing so. So you'll see it's fairly similar to the law that was in place beforehand, except that there was that requirement to know that harassment had taken place before. Has fallen away. So whereas the old law was fairly reactive in terms of you had to know that something had happened and then reacted to it and put some provisions in place, the new law requires you as employers to be much more proactive in making sure that you've got some steps in place to prevent harassment. You'll see the government have identified some exceptions to that in the draft bill. There's a slightly frustrating double negative that you'll be able to see. So employers won't have failed in their duty if they've taken reasonable steps. So there are things like if the alleged harassment involves a conversation where your employee isn't the participant, so they're just at work and they overhear something that isn't directed at them and they're not party to, then the employer won't be liable for that, and that is an exemption. Or where the conversation or the speech, whatever it is they've heard, isn't grossly offensive or indecent. And the type of things that we're talking about when we're saying things that they've heard that could be harassment are opinions on political things, religious things, social justice, etc. You're probably wondering what that kind of looks like. So what are reasonable steps? How do you get over that threshold? How do you know if the comment that they've heard is grossly offensive? The simple answer is, at the moment, we actually don't know. So we've got to wait for the government to put that into the bills and get the draft guidance and legislation out, and then we'll see what actually is expected of employers. But it's just worth you having that kind of background knowledge that this might be coming in, and actually a lot of us are alive to harassment at work things now anyway from current news stories, so you've probably already got things in place. A little bit of extra information that isn't on the slide. There is also likely to be some harassment rules coming in that require you to take reasonable steps to prevent sexual harassment in the workplace. We will cover that probably, I'm looking over at James and Nick, in another seminar at some point in the future, because again, we don't have the details on that, and it looks as though that will be even more onerous on the employer, because there is a potential that there will be an uplift to any compensation for an employee that succeeds in any claims that came from that, and that we're expecting that will work in a similar way to breach of ACAS code type of things with a 25% uplift. But again, we will cover that in more detail once we've got the information, but just one for you to keep an eye out on over the coming months. There's also some rules, as Nick was saying, so there's a whole overview of flexible working coming in, and one of those things that is being looked at is the idea that people who have irregular hours can ask and request for a contract that recognises normal working hours. So the type of people that we're looking at here are people on 0 hours contract or anything that is an irregular working pattern. Again, there's some final details to iron out here, so apologies for the lack of absolute clarity on what will be coming in. But we anticipate that this will work in a similar way to flexible working requests, which Nick's just given us a recap over. So we are expecting that for any of these workers with irregular hours that would like to put in a request for normalised working hours, they will still need to meet the usual thresholds of 26 weeks service, and then various different ways of getting that in. There will still be the same sort of rules that are in place at the moment, in terms of you will be able to refuse to do this. It isn't an automatic right that they write in and say, please can have normal working hours, and they get it. It's the right to request that they do that. And as with the current rules on flexible working requests, there are specific ways in which employers can say no. For example, they've looked at the impact it has on the business, and we're always happy to talk you through those. But on this one, again, we're expecting this to mirror it. You might have seen that there's also been some consultation on providing a right to reasonable notice of working hours and providing workers with compensation for shifts cancelled. That hasn't come to fruition, so we haven't seen anything come through to the new guidance that is being proposed, and it is mainly focused on that bottom bullet point, which is all to do with recognising normal working hours. So let me just flick through. And then the next one, and again, it's a little bit bitty, we're now looking at enhanced redundancy protection. So I know that we've done a number of redundancy consultations with many of you over the last couple of years as a result of the COVID lockdowns and the resulting impact. So some of you will have had to factor this into your redundancy consultations. The current position is anyone with any additional protection, so people that are on the types of leave on the slide, so maternity leave, adoption leave, etc., may have an automatic right to be offered any suitable alternative vacancies. So if you've got a redundancy pool with 3 people in and you've got someone that's on maternity leave, the person on maternity leave would be the person that has the automatic right to be offered a suitable alternative vacancy. At the moment, there is no enhanced protection for pregnant employees or anyone that has just returned from maternity leave. What we are expecting is that there will be some new changes to that kind of those kind of rules, and we're expecting it to be an extension of the existing rules, but to cover more people, so those that are on or have just returned from a protected period of pregnancy, or people that have just returned from maternity leave. So using the example that I just gave in the previous slide, if you've got the 3 people that are on redundancy consultation and the person has actually just returned from maternity leave, at the moment they don't get any enhanced additional protections, but if this new rule does come through and does pass and get into legislation, then it's expected that they might. Again, we haven't actually had any specifics on who will be included and how it will work. So bizarrely, what they've actually done is just given provision for the Secretary of State to make provisions to amend the enhanced redundancy protections. They've not told us what they're going to do with that and how that's going to work. But at the moment, it's looking as though it is going to include providing protection against redundancy during or after the types of leave that are already identified, so adoption, maternity, shared parental, and that obviously extends it beyond what it currently is. As soon as we have any details, we'll of course let you all know. I think I'm now handing over to Rakaya.
Thank you, Laura. Good morning, everyone. So sticking with the theme of whether this year is the year of the employee, we're just going to be talking about some of the new family-friendly leave entitlements. So the first one is a new right to carers leave. So this will be a 1-week unpaid leave per year for employees who are providing or arranging care for a dependent with a long-term care need. So this leave can be taken flexibly. So it can be taken, for example, for half a day and then in day blocks following that, or it can be taken in a single week block. What's important to note is that what won't be covered by this type of leave is childcare in its ordinary capacity, unless, of course, that child has a disability or a long-term care need that falls in scope with the regulations when they are published. The next right is a new right to neonatal care leave. So this will give parents of a child who is receiving or has received neonatal care a statutory entitlement to 12 weeks leave. So this is going to be in addition to their already parental leave entitlements, such as maternity leave and paternity leave. And it will apply to babies who have been admitted into hospital up to the age of 28 days. So 28 days old, and then if they've stayed in hospital for 7 days or more, then this entitlement applies. It can be taken up to 68 weeks from the child's birth, so it can be taken, as far as we know, it can be taken at a later date as well. And employees with at least 26 weeks service will additionally be entitled to neonatal care leave pay, and that will be at the same rate as the other statutory leave entitlements. So next, we're just going to go on to speaking about some of the new rates, statutory rates that are coming into force from April 2023. So that's going to be next month now. So all national minimum wage rates are increasing by nearly 10%, so 9.7%. And the national living wage is going to be rising to £10.42. So that's for those aged 23 and above. So that's just something to bear in mind. Statutory sick pay is also increasing to £109.40, and the other types of family leave entitlements are rising as well. And this has been said to be the largest increase to the national living wage since its introduction, and it's supposedly meant to reflect the steep rise in inflation and the cost of a living crisis. Now, whether that's adequate is another question, but just something to bear in mind that these rates are going up. Now I think I'm passing over to James.
Yes, thank you, Raquel. I was just trying to answer the question.
James, I think you're on mute.
Yes,
Classic.
thanks, Nick. Yeah. It's a COVID generation problem, isn't it? Not unmuting oneself. Yeah, I was just saying I just a bit slow in coming on because I was just trying to pop an answer in the chat about grandparents. I think the answer is yes, assuming they're still employed by someone. Otherwise, it's just a deal with the parents, non-statutory. Well done for getting this far. We've now got the graveyard shift of holiday pay. It wouldn't be one of these updates if there wasn't something about holiday pay. Slightly different theme. We're going to move away from the one you all really loved, which is where you assessed every worker's overtime and commission to see if they did it sufficiently regularly to become normal, and move on to the even more complicated world of part-time and irregular hours holiday pay. And there's been some sort of rumbling in this area, and more people have got wind of it as the Harper Trust v Brazel case has gone through the various courts. But now it's finished insofar as the Supreme Court has agreed with the Court of Appeal. And so everyone now realizes we're absolutely stuck with it until something changes. So first, it's worth mentioning, what are we stuck with? Well, what the Supreme Court has said and what the Court of Appeal has said is that the working time regulations, in essence, work in two ways. The first way is that every worker accrues holiday immediately from starting employment, and that the rate that they accrue it under statute is 5.6 weeks per year. So every worker, regardless of how much work they do, after 1 year, assuming that they start at the start of the holiday year, which they probably didn't, would accrue 5.6 weeks. And then the second thing they said is, and for those 5.6 weeks, they should be paid a week's pay. And if you have irregular working hours, you don't need to worry so much about the business that we did after Bear Scotland about looking at what's normal and what's not normal, and you just do an average. And what Harper Trust revealed, and the facts of the case are probably worth going into for a second. Miss Brazel was a music teacher who did bits and bobs of work during term time for the Harper Trust, but some weeks she did no work at all, other weeks she did lots of work. And they paid a holiday pay based on the what was quite popular 12.07% method, where they just paid a 12.07% of her total earnings as her holiday pay to cover the non-term time. And what she said was, that's wrong, I'm getting underpaid. And what the Court of Appeal and the Supreme Court said is that she was right. And the reason is because of this business of a week's pay. Essentially, the way you work out a week's pay, as I said, is a mathematical average, but you discount any weeks where the worker earned no remuneration at all. So if you were just doing 12.07%, that vagary would not be there, because from Maths Geeks out there, you're using a smaller denominator. That one's essentially assuming that the work is spread out over the whole year, whereas the correct way is to just work out an average of weeks actually worked. So she was significantly underpaid. And what taking this to its sort of logical conclusion is, for part year and term time workers, the more weeks in the year that the worker does where they don't earn anything at all, the more wrong the 12.07% method will be, and the larger the underpayment of holiday will be. And so she was awarded some compensation, or she will be when it goes back through to the tribunal. And a lot of people pointed out, possibly rightly, that this is a bit perverse, because in the case, one of the advocates used the example that what happens if you have someone employed as an exam invigilator and they do 2 weeks work a year and they get paid £100? Do they get paid £560 a year in holiday pay for doing £200 worth of work? And based on the law, the answer to that is yes. So they'd get nearly 3 times as much holiday pay as working. And that's the anomaly. But the judges were saying, but that's not our fault. That's just what the law says. And we can't interpret it a way that's inconsistent with what it says, even if it does arguably provide a bit of an absurd result. I would comment that you wouldn't necessarily need to employ an environment invigilator all year round to work 2 weeks a year. There's lots of other ways you could do it that meant they weren't employed the whole year. But you might not have been worried about this holiday pay problem. And the other thing on the current law on holiday pay that's worth flagging is that some employers still do what's called rolled up holiday pay. And by that, I mean, they just make a payment in respect of holiday accrued. They don't make payments specifically for time that is not worked, where they get paid. So the regulations assume that employee is going to work for some of the year and not work for some of the year, and that the holiday period where they're not working is when they get paid. And the problem with the rolled up holiday pay, as well as being technically unlawful, is that it's likely again to lead to the wrong calculations, because you can't be calculating from when they're taking leave, which is what the law requires, if they're not actually being paid at the time they're taking the leave. So rolled up holiday pay, whilst you might be able to offset what you've paid, is again likely to create some anomalies. But as I said, the extent to which the 12.07 method is wrong depends on the pattern of worker. So it'll be a bigger risk for some people and less so for others. Now, unsurprisingly, the government thinks it's a bit unsatisfactory, this law, and so they've opened up consultation that closes relatively soon. If anyone did want to feed back into it, you've got not much time left, to try and solve this problem with the aim of providing clarity, removing barriers, and to make things simpler, because as I just outlined, it is horrendously complicated. So what's the likely practical outcome of this consultation? Well, oddly, the way I'm reading it, and the consultation preamble, if you've read it, sort of hints as to what line the government might be going down. Well, I think it does anyway. And that's to essentially get to somewhere akin to the 12.07% method that's been proven to be incorrect under the current law. And that's to make holiday entitlement and pay proportionate with the time a worker actually spends working, as opposed to the time spent employed, which is what the 12.07% calculation does. For those of you wondering, where did 12.07% come from? Well, firstly, it was in some ACAS guidance that they put up suggesting how you might calculate holiday pay for casual workers, part-year workers, but that got taken down when Harper Trust was getting through its process when they realised it was probably wrong. But the actual mass is 12.07% is got by taking 5.6 weeks, dividing it by 46.4 weeks, which is the part of the year you've worked out of 52 weeks if you don't work for 5.6 weeks, and then multiplying it by 100, just for those that are curious. And that's how you could work out a method of accrual. And I think a second problem that we need to fix, I often get asked this, and I don't have a good answer because there isn't one as far as I'm aware, is the problem of everyone's holiday under the statute being a function of weeks. So if you don't know, if someone has an irregular working pattern and they have a week's leave, what does that actually mean if the purpose of booking it? If the premise of the rules are we're supposed to book the leave, but they work in irregular hours, what is a week? Because we can work out what a week's pay is, but how can we work out what a week is? And then if they don't want to take a chunk of a week, what do you do then? So I think the law needs to be clarified to explain how you take entitlements in weeks and put them into hours or days, or alternatively get rid of the whole business of weeks and just start off with days and hours and prorate from there, because that to me would be a lot more workable. Because the third bullet point highlights the problem for casual workers, term time workers, agency workers. They don't really know where they stand with holiday at the moment. I've worked with lots of different employers that are all doing slightly different things, and it's almost impossible to say anyone is doing it rightly or wrongly. All you can really do is work out whether or not you've paid enough in terms of holiday pay, and then look towards the fact that can we show that they've at least had chance to take 5.6 weeks off per year where they didn't work and they were paid. So it's a bit of a minefield, and hopefully the law will be clarified. The kind of good news is that there's more scope to fix this now than there's ever been, because there's no need for there to be a requirement that any law they do pass is consistent with the EU directive, and it needn't be interpreted in line with it, which up until Brexit would have had to have been the case. So that there is a bit more hope, I think, on this. The only sort of caveat I'd say is that we're still stuck with the complexities I mentioned earlier for the foreseeable future, because unlike the previous speakers who were talking about bills that are going through Parliament, this is prior to that. This is just a problem that's identified that they're consulting on. We'll have to wait for the bill and then hopefully a change in the law in the future. Moving on to another positive topic, fire and rehire. You've probably all heard about this in the press when P&O did what they did, which I've put as confusion because it was sort of slightly misreported in that it was talked about fire and rehire and this awful practice that employers have of firing and rehiring people. But P&O didn't even do that. They just fired people and then hired different people from abroad for a lot less, which isn't really what dismissal and re-engagement is all about. So what is the current position? Bearing in mind that there is now a draft statutory code, which is quite long, 16 pages, and I'll come into what it says in a second. Well, the current position is that if you dismiss someone and offer them re-engagement on new terms, and the reason you dismiss someone is because they wouldn't agree, then you can argue in the employment tribunal, if they don't accept the new terms, or even if they do, that dismissal was fair. There's case law that says that dismissal for this reason, not agreeing the new terms, comes within the lovely catch-all some other substantial reason head. And then there's other case law that helps analyse whether dismissal for that reason is fair or unfair. Now, I actually did a case on this very point up in Manchester in December of 2016, and it involved, I don't know, those of you that remember the living wage when it was a new thing. So the 21-year rate of the 21 years of age rate of the national minimum wage. What my client did was they wanted to get rid of shift premiums because there was quite a big jump in the minimum wage. And if you added on 5-10%, that pushed everyone's wage up quite significantly. So they wanted to renegotiate contracts to get rid of the shift premiums and just agree a flat pay rise. But they got into a bit of a tangle, and the pay all went up before they had a chance to renegotiate the contracts. So as of the date the national living wage came into force, everyone had to be paid the national living wage. They applied the percentage and the pay went up. And then shortly after that, they managed to complete their dismissal re-engagement process, where anyone who hadn't agreed to reduce their pay again was dismissed. So it's a slightly odd situation where pay went up. So yeah, it went up. And then if they agreed, down a little bit. But we were able to defend that case, applying the current case law and the current law, primarily because they consulted extensively with the trade unions. They came to agreement with the vast majority of employees. So it was only a handful out of a significant number who were dismissed. The consultation was thorough. It took a long time. They looked at all the available options. They could say that they were actually giving everyone a pay rise in the round. There was just this slight anomaly period where people were paid more because they still had that. Essentially, the submission I was making is that they wanted their cake and eat it for that short period of time. So it could be done then. And so I was keen to see if I'd have been arguing that 2016 case under this new code, how different would it be? The answer to that, I think, is not very. The code contains practical guidance and essentially codifies a lot of stuff that was hinted at through the various case law that has existed for a number of years. One of the things the code does, in much the same way as the ACAS code on disciplinary and procedures does, is that if the code applies, so you're in a dismissal re-engagement situation and one party or the other doesn't comply with it and a dismissal is unfair, then the tribunal could uplift or reduce compensation by up to 25%, depending on whether they want to and the gravity of the breach, for breach of the code. So the employee could breach the code, for example, by not engaging in the consultation, the employer by not doing consultation. And the consultation for this type of process is largely analogous to a redundancy consultation. The code sets out a step-by-step process, which probably isn't hugely surprising. It's to do with communicating desire to change terms, reassessing the business strategy behind change terms of no agreement. So essentially not being deaf, it needs to be a two-way process. The employer needs to be open to what the employees or their representatives are saying and react to that, not just go through like a freight train, paying no meaningful engagement with it. It says disciplinary engagement should be a last resort, but I think that's what most people see it as anyway, because it's a dangerous game, because you risk losing people if you dismiss, if they don't opt for re-engage. And there are some sensible points about keeping things under review and offering practical changes. I mean, if some of the changes, things like if you're moving office, practical support could be for a short time offering transportation, for example, although that'd be more of a redundancy situation. Unintended consequences I've put on the slide, and what I mean by that is, in my sort of experience, employers were very loath to go through a process of dismissal re-engagement, and that the case law wasn't widely known. And I think perversely that having a code might almost give employers a bit more confidence that you can do this if you follow the code. And the code does make it quite onerous, and there's quite a lot of procedural steps to go through. But on the flip side, an employee will at least see that there is a process, a roadmap to follow, and so will trade unions. So you might actually get perversely a bit less resistance on the whole premise of it. But nonetheless, no doubt the consultation itself could be quite tricky. But there might be an acceptance that this is a thing, rather than in some cases where people think that you just simply can't dismiss and re-engage, which was never the case, but was certainly something people thought. Right, that's it for fire and rehire. We're now going to look at some cases.
Thanks, James. Great stuff. So we are going to look, as James said, at some cases, fairly recent cases. Again, we're going to try and make it a bit interactive, so you'll get to vote in the poll on some of these too. Which is very exciting, I'm sure, for you. But if we run through the facts of this first case, this involved a male manager and a female junior, who the tribunal described the fact that they had developed an obvious enjoyment of each other's company, which went far beyond a good working relationship. And having read the judgment, that there was quite a bit of detail as to quite how involved, shall we say, that relationship was, and I think an analysis of something like 800 or so messages between the two employees while at work. I think on Teams chat or Slack or whatever it was, and I guess some HR teams or employers might well have been thinking, well, when were they doing any work? But it was quite an extensive period of time where they clearly had become very close. However, the male manager made, again, what the tribunal described, and you've got to love employment judges, romantic overtures. I'm sure the employee himself didn't describe it as that, but that's how the judge described it, towards that female colleague, though they were not sexually explicit in their nature, and certainly, again, reading the judgment compared to some of the cases that we've either read or dealt with, it wasn't as extreme in that nature as we have seen. However, the female colleague eventually raised an allegation of sexual harassment, but in this case, the employer suggested that the grievance that she'd raised, essentially, that process was being used in bad faith by the female employee. Perhaps unsurprisingly, the female employee brought claims including sexual harassment. So this is where we get to predict the outcome of the case. And Matt hopefully will launch a poll for us, which will allow you to vote on that outcome. So I'll whiz through. First option, what did the tribunal decide? The fact that the two employees had developed a close personal relationship and the manager was not sexually explicit meant the claims failed. Or the allegation of harassment was upheld and the failure to take the grievance seriously made it worse. Or the tribunal found that the employees had become close and workplace romances are commonplace. How else do you meet anyone when you work a busy job? So let's see what we think. So we've still got a good few responses to come through. Just a few more. Yeah, I think we're almost there. And it's looking like a fairly overwhelming response for option 2, that the harassment claim was upheld and the employer's failure to take it seriously made it worse. There are a few opting for the other 2 as well. Okay, so let's have a look. So you were right in your assessment, those that opted for that middle option. The case itself was reported with some names anonymized, but effectively it's Volcker Rail as it's generally been described. And the remedy hearing was in July last year, so they decided how much would be awarded, and you can see from the slide it was a pretty significant award, and that's because yes, the tribunal found that there had been harassment and various other claims were made out as well, but the process for managing that grievance was so badly managed that in fact that itself was further harassment, and that the grievance outcome was actually designed to avoid that manager having to deal with the stigma of sexual harassment. The award, as you can see, was not far off £500,000, and I think the female employee earned about 50,000 a year, so it was a pretty sizable award, and it comprised loss of earnings, injury feelings, and actually psychiatric injury. So I think the contribution that the employer made by dealing with it so badly actually made the individual quite unwell, because obviously, understandably, she will have felt not protected by her employer in that way and not taken seriously. And yes, it was a pretty significant award in those circumstances. I guess that the lessons learned there are workplace relationships will happen. They're often difficult to manage as an employer, but treading carefully and taking things seriously clearly is very important. The other thing, obviously, is getting those policies, procedures right, taking people's concerns seriously, but also I think training your people on these issues too. So managers being aware of the risks around diversity, inclusion, relationships at work, all that kind of stuff is clearly really important too. And we're seeing plenty of clients at the minute looking at rolling out training programs to make sure that their employees are aware of those things or reminded regularly about those things in order to try and avoid situations like this, which obviously can be pretty costly. So that's case study 1. On to case study 2.
Sorry guys, now I'm muted. Thank you. So case study 2, the employee here was dismissed for gross misconduct. So this person was having a really bad day at work, got very upset about things that happened, abandoned ship and left for a while. After being dismissed for gross misconduct, then exercised her rights to appeal. So prior to the appeal, she told the employer that she didn't want to be reinstated to her role and was very clear in that fact. But the appeal outcome was to allow her appeal and reinstate her to her original position. So at the same point that she was expected to return to her position and part of the reinstatement, she also presented an ET1 claim to the tribunal as an unfair dismissal claim. So that was at the point that she'd been reinstated and had not actually been dismissed. And then there was a later dismissal for refusing to work, but the ET1 claim went in before that later dismissal. So what did the tribunal decide? So because the employee clearly said that she didn't wish to return to work, she could pursue an unfair dismissal claim based on the original decision to dismiss her for gross misconduct. That because she'd said she didn't wish to be reinstated, she had withdrawn her appeal, and therefore she could pursue the unfair dismissal claim based on the original decision to dismiss her for gross misconduct, or the claim for unfair dismissal failed as the employee was not dismissed prior to presenting her claim. The original dismissal was deemed to have vanished because the appeal outcome was reinstating the employee. I can see a few of you putting answers in. It looks as though we've still got a few to go, a very mixed reaction at the moment. Yep, still fairly even across all three. I think we've got a few more of you, so I'll just wait for a couple of seconds. Okay, it looks as though we've got quite a few. There's a few more to go, so please continue voting if you'd like to. So we've got a real split across on this one. I will give you a couple more seconds if anyone still wants to put their answer in. There we go. So we've got a very broad mix on this one. The percentage that's winning, the bottom one, that is the correct answer in this one. So the claim for unfair dismissal failed as the employee wasn't dismissed prior to presenting a claim. So the original dismissal was deemed to have vanished. So the tribunal said that dismissal had vanished following the successful appeal, and therefore she couldn't bring the unfair dismissal claim because the dismissal had gone and there was no dismissal. The later dismissal was irrelevant because it had happened after the ET1 claim form had been presented. This then went all the way up to the Employment Appeal Tribunal, who then upheld the tribunal's decision and said that because she hadn't withdrawn her appeal, so it wasn't enough to say, I don't want to be reinstated, that wasn't a withdrawal, that she had actually been reinstated, there was no dismissal, and therefore there could not be any unfair dismissal claim succeeding. I shall now pass this across to the next person.
Although before you do, Laura, you've been very modest in not disclosing the fact that that was a case that you ran yourself to the EAT. So well done on that one. That was one of our own that we've had to stay fairly quiet on, and while other employment lawyers make lots of noise about the outcome. So good job. It's nice to be able to talk about it.
Thank
James.
You.
Well, this very much wasn't one I acted on, before anyone gets the wrong idea. But case study 3, this is the toilet case that we were billing. So it's slightly odd facts in this case. Women's toilets were in part of a building used by a playgroup. The actual respondent employer operated from a church. They weren't part of the church. They also just used the building. And because of the playgroup, and the issues of safeguarding, so people not going to the toilet when there were children from the playgroup using the toilets, the female employees often had to use the men's toilets because the men's toilets was away from the playgroup and you didn't need to go through the playground to access it, whereas the women's you did. Now, the second point of the slide describes the men's toilets, which sound like a fairly standard men's toilet. And the third suggests a slightly strange bit of DIY, where because women would be using the men's toilets from time to time, they came up with a fairly primitive sounding sign that didn't apparently always stay in place. And the other sort of key fact is that there was one particular employee who didn't like the fact that she had to use the men's toilets. The facts say there was no sanitary bin, and one of the things she had to do is, if she wanted that bin emptying, she had to tell the caretaker, which she described as demeaning and an invasion of privacy. So she put in her claim for sex discrimination before a subsequent dismissal. That was irrelevant to the case, but the actual part of the case that was interesting was this question: did the employees claim that the toilet facilities were inadequate for women constitute direct sex discrimination? Or I've worded the question a bit awfully wordily. Did her claim that they were adequate constitute direct sex discrimination to succeed? So did she win with her claim, or did she lose? It's a nice, easy yes or no, unlike some of the previous questions, that were a bit more nuanced. Well, this is looking fairly overwhelming, so I don't think I'm going to wait for all the votes to be in. The vast majority of the people think yes. And yes is exactly what the Employment Tribunal and Appeal Tribunal agreed was correct. And essentially, they started from a position of saying, what were the state of the toilets? For women, they were inadequate. They said it was unacceptable that she had to say to a caretaker that the sanitary bin needed to be emptied. And the killer blow, really, I think, for the employer was that subsequent to the claim being put in, or at least later down in the factual narrative of the claim, they solved the problem by putting an external lock on the door. So the arguments that they made were sort of tempered by the fact that the two things that could have solved the problem were relatively easily implemented, and were in fact implemented a few months later. There was some discussion about whether or not the treatment was actually less favourable towards women as such, because the decision making by the employer was not really related to women and men. It was more, well, it's not our fault. The reason that it's inadequate is because the playgroup and the building is inadequate. It's not a sort of conscious choice of women and men. But essentially, the law said that doesn't matter. It was inherently because of sex, because it did treat the women less favourably. The women have to use the women's loos, the men use the men's loos, or generally speaking. And so the fact that the actual comparison that they made was men's loos adequate for men, women's loos, insofar as they have to use the men's loos, inadequate. Therefore, it's sex discrimination. And as I say, the killer was the fact they could have fixed it so easily with things that were just common sense steps that they then ultimately did do. So that's that.
Thanks, James. And just one final case, which we included. There isn't a poll on this one, but it's interesting because I think in a few places it's being misreported. So this is Ellingham and Tempur, who I think make mattresses and pillows and that kind of thing. And it's being reported almost as though COVID-19 skepticism is a protected belief under religion or belief in the Equality Act. And that's not quite the case. I'll explain why in a second, but clearly over the last number of years, there's been a fair amount of COVID skepticism, conspiracy theories and the like. And, we've seen plenty of that. And this Employment Tribunal case involved someone who was basically saying, I have been treated less favourably as a result of my philosophical belief, which I think should be protected, which is COVID-19 skepticism. And the background to this is that religion or belief discrimination, the religion bit is often easier to define and it is a bit more straightforward. But the philosophical belief, there's a test that the tribunal apply following a case called Granger, where they in theory can establish new areas where a belief is protected. And this chap was saying that COVID-19 skepticism was that, and that it should be protected for him. He, for example, said that he believed in his personal responsibility for his own health and his free will not to have to do something that he didn't want to do. And he was citing things like not wanting to wear a mask and not wanting to have to use hand sanitizer and all this kind of thing. It's being reported in some places that this is almost as though this is a protected belief now. What actually happened was that this is a reported preliminary hearing where the employer, perhaps unsurprisingly, had applied for the claim to be struck out. And the decision in reality was that this bit of the claim, other bits were struck out, but this bit of the claim wouldn't be struck out, and that they would actually hear evidence as to whether COVID-19 skepticism meets the test necessary to become a protected belief under the Equality Act. So it's still a live issue, but not yet confirmed as protected under the Equality Act. So hopefully that's helpful, and again, it's one of those ones just to keep an eye on, or to be properly informed should you see any headlines suggesting that that is now protected under the Equality Act. And that brings us towards the end. We've got a few kind of mopping up slides, which I'll run people through as we go, or as we finish, I should say. But any questions that anybody has, we've had a few in the chat as we've gone along, which has been great, and we've covered a lot of those, I think. If anybody else has anything, either pop it in the chat now, or if you're feeling brave, unmute and fire away. If not, that's also fine. That's great, no problem. So thanks, Andy and Maria. So I'll just whiz you through our last couple of slides. This is essentially a bit of advertising from us. We're running some free employment contract and employee handbook reviews at the minute. So off the back of the Good Work Plan and the Matthew Taylor review in 2020, which obviously was just before COVID, there were some changes that are required for the purposes of employment contracts in particular. And lots of employers have missed those because of COVID kind of getting in the way. So we're doing a free review, effectively checking your contracts for legal compliance, and we would be happy to help with that. We're also seeing a massive increase in requests for training, as I kind of mentioned briefly earlier on a whole range of topics: investigations, disciplinary grievances, diversity inclusion, performance management, sickness absence management, all that kind of stuff. And we offer training on that either online or in person, and we'd be really happy to help if you would like training for your teams. We also run, and I know a number of you will be aware of it, something called the East Midlands HR Network, and Matt may well be able to post details for that. If you're an HR professional, we'd love to see you along to one of those events. It's fantastic to get people together from the HR profession there. And also we have a podcast coming soon. Again, some of the people on the call have actually been interviewed by me for the purpose of that podcast, and we're looking forward to launching that shortly. So hopefully that will be useful for the HR community too. And then finally, on our next webinar is titled HR Essentials. Now, it may well be that you have junior HR people in your teams who would find this useful, but in reality, this is aimed mainly at non-HR professionals who could just do with a recap on the basics of HR or employment law. So if you're an HR person on the call, many of you are, most of you are, and you have perhaps an MD or an FD who might benefit from a recap on HR issues, and you'd like us to help upskill them, then that would be a great webinar for them to join us at. So please keep an eye out for that invitation hitting your inbox, and feel free to pass it on to them. because it will be targeted at people who generally aren't doing a huge amount of HR stuff day to day, but would really benefit from hearing more about it. So that's, I think, the end of our session together. So thank you all for joining us. Hopefully it was useful. Lots of good feedback in the chat, so thank you for that. And we look forward to seeing you or perhaps your non-HR colleagues next time. Thanks, guys.